Your Honour, if it pleases the Court, my name is Griffiths, initial N, and I appear for the applicant, Mr. Johnny Wishbone. Your Honour, I submit an application to the Court for the exclusion of evidence brought by the prosecution on the basis of substantial non-compliance with the Police Powers Responsibility Act in line with Section 130 of the Evidence Act and Section 590, capital AA of the Criminal Code, Queensland. Your Honour, the facts are as follows. My client is a 16-year-old Torres Strait Islander juvenile who has been charged with 106 indictments. He was detained and arrested by plainclothes police officers after they responded to a break-and-enter call. The police then drove my client around the streets in an unmarked police vehicle. They pointed out various houses that had been allegedly burgled, asking my client if he had committed the offences. My client was finally taken to the police station where he was appointed a social worker and was then further questioned by the police where he made full admissions. Your Honour, my client has been incarcerated for 3 months awaiting trial. Your Honour, the applicant makes 2 submissions to the court. First, the admissions obtained from my client during the ride in the police vehicle should be excluded from evidence as they were obtained in breach of the Police Powers and Responsibility Act. And secondly, the electronic record of interview should not be admitted into evidence as it is too prejudicial to my client as it was obtained in breach of my client's fundamental rights. The first statutory breach of procedure by the arresting officers occurred when they failed to properly identify themselves to my client. As prescribed by Section 22, subsection 2 of the Police Powers Responsibility Regulation, a police officer is required to identify themselves by name, rank, and police station. The officers then failed to caution my client of his right to silence. By failing to advise my client of this fundamental right, the police officers are in breach of Section 397 of the Police Powers Responsibility Act. They have further breached Section 431, subsection 1 of the Act by not complying with Section 9, Schedule 9, Section 26 of the Police Powers Responsibilities Code. Highly relevant is the decision in the Crown and Swaffield, where the High Court held that the accused's confession should have been rejected as evidence on the grounds that it was obtained in breach of the accused's right to silence. Secondly, the confession obtained from my client during the car ride is in breach of Section 436 of the Police Powers Responsibility Act. The police failed to electronically record the conversation with my client in the police car and then further failed to make a written record as stipulated in Section 30, subsection 1 of the Responsibilities Code. This undocumented confession forms the basis for the admissions by my client in his record of interview, and due to the breach in statutory procedure, it should be excluded from evidence. Additionally, the police made no attempt to establish my client's age or cultural identity. My client is a 16-year-old Torres Strait Islander, and Section 421 of the Police Powers Responsibility Act has strict statutory requirements that need to be fulfilled when questioning a child. Subsection 2 stipulates that police must not question a child unless the child has a self-appointed support person. By taking my client to various locations and asking him questions without a support person, they have contravened the requirements of the Act. Eventually, the police provided my client with a police-appointed social worker at the police station. However, Your Honour, my client did not know the worker and did not consent to her being his support person. By failing to contact my client's family, friend, or lawyer, the police have further breached Section 23 of the Responsibility Code. Furthermore, Section 420, subsection 2 of the Police Powers Responsibility Act outlines procedure when questioning an Indigenous or Torres Strait Islander. Under subsection 2, the officers failed to inform legal aid that they had my client in custody for an offence. Further, in Section 25, subsection 3 of the Police Powers Responsibility Code, the officers failed to establish my client's level of education and understanding before questioning him. Your Honour, if the police had complied with this section, they would have realised the responses made by my client indicated gratuitous concurrence and were used as a way to manage his stress in this situation. Your Honour, after considering the relevant sections of the Police Powers and Responsibility Act and the Police Powers Responsibility Regulation, I humbly submit that the police failed to adhere to proper procedure and have breached statutory regulations, resulting in a miscarriage of justice. The purpose of the Act outlined in Section 5, subsection E, is that the police officers have an obligation to ensure fairness and protect an individual's rights under this Act. By denying my client the right to silence, a support person, and failing to adhere to correct documentation of evidence, any confession obtained by the police is unfairly prejudicial and should be excluded as evidence, as it would result in an unfair trial. I refer Your Honour to the Christie discretion, adopted in Australia by the High Court in the Crown and Lee, which found that some evidence, although has some probative value, is too prejudicial to allow a fair trial, and the Court excluded evidence on these grounds. Further, I implore Your Honour to exclude my client's record of interview from evidence and to release my client from custody immediately. To admit the prosecution's evidence would be an abuse of process and would undermine the public's broader respect for the rule of law. Your Honour, if you find that the conduct by the arresting officers contravenes the relevant sections in the Police Powers Responsibility Act, the Court can exercise its inherent discretion as opined in the Crown and Island and then adopted and expanded in Bunning and Cross, which allows the Court the discretion to refuse to admit evidence if it has been unlawfully and improperly obtained. If I can be of no further assistance to the Court, that concludes my submissions.